So Anthony had mentioned earlier about some of the there's certain procedural safeguards in class actions, but PAGA claims are not subject to those procedural safeguards. So the amendments to the reformed PAGA law now give trial judges a lot of enhanced powers to limit evidence presented at trial or limit the scope of the claims to ensure that the case is manageable and may be effectively tried. And this is a really important area, this concept of manageability. You know, can the plaintiff present a case at trial in an efficient manner without having to have hundreds or thousands of mini trials for each employee? So this is great news for employers. I anticipate that defense counsel are going to be at all stages of the litigation, especially right up front, doing everything to get on calendar before the judge, motions and briefings on is the case manageable? Should the evidence be limited? Should we not have discovery because the plaintiff only has standing for an overtime claim and does not have standing to pursue a meal break violation? So there's lots of this area of judicial discretion and manageability. There'll be lots of questions that are yet to be answered, and lots of opportunities for the defense counsel then to make in the court case. The next thing that I'm going to talk about is employers who are currently have a weekly pay cycle are no longer going to be penalized just because they pay wages on a weekly basis. Employers paying on a weekly basis will see reduced penalties, and this will address the disproportionate penalty when you have another employer who pays on a biweekly or semi-monthly cycle. Because PAGA penalties are on a per pay period basis, employers who paid on a weekly basis versus biweekly faced a higher potential penalty award. So the reformed PAGA law now reduces penalties for employers who pay weekly by 50%. And this is just, one of the many benefits and relief for employers in these PAGA cases.
Just a quick comment on that too, Andy. We had a lot of clients that were trying to pay their employees weekly. The employees preferred that. And our advice before this reform came through was don't pay weekly because you just effectively doubled your PAGA penalties because it's on a per pay period basis. And you're not required to pay weekly. You could go bi-weekly or semi-monthly. And so this reform allows employers, especially in the hospitality industry, where a lot of the employees are looking for that paycheck each week, to go to the weekly pay period and still have the same equivalent liability. You're not doubling your penalties because you're paying weekly now.
Yeah, it is ironic that, that so many employers pay weekly, and that's a benefit to the employees, and the employees expect that. And yes, there are multiple times that we advised our clients, during active PAGA litigation to switch to a different pay cycle. And in fact, they did switch to a different pay cycle, and the employees, to the detriment of the employees. And so they missed out. So now, you're no longer going to be penalized for that.